Hello bachcho, let's see passage 2. It talks about the terms false what does the term false signifies? It signifies wrong, and the term imprisonment signifies confinement or detention. So the false imprisonment is confinement of an individual. What is it? It is confinement of an individual with no legitimate justification. It is the complete restriction of it is complete restriction. Pay attention, of one's liberty and freedom of an individual. It also violates the fundamental right of an individual. In this act, the defendant deprives the personal liberty of plaintiff and imposes his authority on him. False imprisonment does not require any burden of proof. यहाँ पे burden of proof की कोई requirement नहीं है, and it is actionable per se. That once there is false imprisonment, there is no burden of proof and it is actionable per se. The act of false imprisonment is done with the intent of malice. यहाँ पे intent बहुत important है. Malice क्या मतलब होता है? Bad intent. So इधर bad intent is important. And the fulfillment of the specific object. Unlawful detainment is the biggest reason which give rise to false imprisonment. If the plaintiff would be able to prove that false imprisonment was done by the defendant without any lawful justification or sufficient jurisdiction, then he would be held liable. तो बस इतना ही प्रूफ करना जरूरी है कि कोई लॉफुल जस्टिफिकेशन नहीं था और कोई सफिशिएंट जुरिसडिक्शन नहीं था डिटेंशन का, तो यहाँ पे लाइबिलिटी क्रिएट हो जाएगी फॉल्स इम्प्रिजनमेंट की. देयर शुड बी कंप्लीट रेस्ट्रिक्शन. As we have already read, complete restriction important है on the liberty and freedom of an individual against his will. Malicious prosecution. What is malicious prosecution? Is considered the malicious institution of unsuccessful criminal, bankruptcy or liquidation processes against another without reasonable justification. So basically आप एक malicious institution कर रहे हो क्रिमिनल चार्जेस का, बैंकरप्सी चार्जेस का या लिक्विडेशन चार्जेस का अगेंस्ट अनदर विदाउट रीजनेबल जस्टिफिकेशन. आपके पास कोई रीजनेबल जस्टिफिकेशन नहीं है ये इनिशिएट करने का. दिस थॉट बैलेंसेस कंपीटिंग स्टैंडर्ड टू बी स्पेसिफिक अपॉर्चुनिटी दैट एन इंडिविजुअल ought to have in bringing the criminals to justice and the requirement for restraining false accusation against innocent person. So this helps to restrain any false accusation which are made to an innocent person. It is an abuse of process of the court of law by wrongfully setting the law in motion on a criminal charge. अगर आप अनलॉफुली या wrongfully कोई भी एक प्रोसेस का अब्यूज कर रहे हो तो इसको हम abuse of process of court of law मानते हैं. The establishment in the triangular abuse of the process of the court by wrongly setting the law in motion. अब इसमें आप क्या क्या कर रहे हो? आप wrongly set कर रहे हो law in motion को. It is designed to encourage the preservation of machinery of justice for proper reason, and it also provides a redress to those who are prosecuted without cause with malice. To be successful, the party who files the suit must prove that there was a prosecution without just and reasonable reason. अब क्या क्या प्रूफ करना जरूरी है? एक प्रोसिक्यूशन था. प्रोसिक्यूशन कैसा था? जस्ट और रीजनेबल रीजंस के बिना था. and it was initiated by malice. Malice मतलब bad intent के साथ इसको initiate किया गया था. and the case was resolved in favor of plaintiff. Obviously अगर आपके against चला गया case तो फिर तो वो तो सही case है, तो ये आपके favor में होना चाहिए decide, तभी आप एक malicious prosecution later on initiate कर सकते हो. It is necessary to prove that damage was suffered by the plaintiff due to the result of the prosecution. यहाँ पे आपको damages भी suffer होने चाहिए in order to get any compensation. Now that we have seen the passage, let's see questions. Question number 6 says, in case the defendant utilized a public footway to set up seats of the spectators of boat race, plaintiff accepting his right to utilize the footway climbed the fencing. He was prevented by defendant and two different gatekeepers to go forward that path. However, he was permitted to go to the other direction. Plaintiff filed suit for false imprisonment decide. तो यहाँ पे उनको प्रिवेंट किया गया था डिफेंडेंट और दो गेटकीपर से कि आप उस साइड ऑफ द पाथ मत जाओ, बट आप डिफरेंट साइड ऑफ द पाथ जा सकते हो. तो क्या यहाँ पे फॉल्स इम्प्रिजनमेंट है या नहीं? वी नीड टू डिसाइड. लेट्स सी द ऑप्शंस. ए सेज देयर वाज फॉल्स इम्प्रिजनमेंट बिकॉज ही वाज प्रिवेंटेड बाय डिफेंडेंट एंड अदर टू डिफरेंट गेटकीपर्स टू गो टुवर्ड दैट पाथ. वी हैव ऑलरेडी रेड इन द पैसेज की कंप्लीट डिफाइनमेंट और कंप्लीट प्रिवेंशन होना चाहिए फ्रॉम मूवमेंट, और यहाँ पे कंप्लीट प्रिवेंशन नहीं था, यहाँ पे कंप्लीट डिटेनमेंट नहीं था, यहाँ पे अदर साइड ऑफ द पाथ जाना अलाउड था. सो डिफेंडेंट cannot initiate false imprisonment, so this is a wrong option. B says there was no false imprisonment because he was permitted to go to the other direction. This is right because complete रेस्ट्रेन नहीं था. यहाँ पे कंप्लीट रेस्ट्रेन इज वेरी इंपॉर्टेंट फॉर प्रूविंग false imprisonment. C says there was false imprisonment because plaintiff accepting his right to utilize the footway climbed the fencing. यहाँ fencing की बात नहीं है, यहाँ पे movement in certain part of the path है, तो यहाँ पे दूसरे direction में allow किया गया था. Again a wrong option. D says none of the above. Again a wrong option. Let's see question number 7. It says in case a member of the legislative assembly suspended on the first day of the budget session who was later captured by the police and his whereabouts were unknown, what would be the judgment of the court upon his wife's application for writ of habeas corpus? अब writ of habeas corpus कब अप्लाई होता है? writ of habeas corpus तब अप्लाई होता है जब unlawful detention होता है. unlawful detention है या फिर whereabouts of the person are unknown. अब यहाँ पे क्या हुआ है कि जो यहाँ पे whereabouts were unknown and wife is filing for an application for habeas corpus. We need to decide कि habeas corpus मिलेगा या नहीं. Let's see A option. The court will uphold the legality of confinement. We do not need to define the legality of confinement or not. Here it is about issuing the writ of habeas corpus and hence this is a wrong option. Let's see option number B. The court will dismiss the application for writ of habeas corpus. No, court will not dismiss the application of habeas corpus because both the conditions that legislative assembly member was suspended and he was later on captured by the police. तो यहाँ पे कोई रीजन नहीं साइड किया गया है, कोई लॉफुल रीजन नहीं दिया गया कि किस वजह से उस लेजिस्लेटिव असेंबली के मेंबर को कैप्चर किया गया था. सो दिस इज एन अनलॉफुल डिटेंशन. एंड सेकंड कि हिज वेयर अबाउट्स वर अननोन टू anybody, already that is mentioned in the fact. So again both the situations are being essentials are being captured here, so writ of habeas corpus nahi grant hogi, that is wrong. C says the court will grant the habeas corpus and order release. This is a right option as we have discussed already. D says court will transfer the case to Supreme Court for further consideration. Here court transferring the case to Supreme Court will be an unusual practice because such writs or detention writs are generally held by lower court and hence it comes within their jurisdiction. So this is again a wrong option. Let's see 8th question. In a case the plaintiff was prosecuted under section 403 of IP. Although that is not our concern कि 403 of IPC क्या है, but I'll let you know 403 of IPC is misappropriation ऑफ प्रॉपर्टी. मतलब यू आर मिस एप्रोप्रिएटिंग अ प्रॉपर्टी. सो यहाँ पे 403 ऑफ आईपीसी के अंडर एक पर्सन को प्रोसिक्यूट किया गया था बट वॉज लेटर एक्विटेड. एक्विटेड के मतलब उनके फेवर में केस डिसाइड हुआ था ड्यू टू रीजनेबल डाउट. सब्सिक्वेंटली ही फाइल एन एक्शन ऑफ मैलिशियस प्रोसिक्यूशन. उन्होंने मैलिशियस प्रोसिक्यूशन फाइल किया. हाउएवर ही फेल्ड टू प्रूव दैट ही वाज हरास्ड बाय द ऑफिसर्स. व्हाट इज द लाइकली जजमेंट इन द present case? Let's see the option A. A says the plaintiff should be awarded substantial damages for malicious prosecution because he was acquitted, indicating the absence of probable cause. Just because he was acquitted doesn't mean that there was absence of probable cause, because we have already read in the passage that he was acquitted due to the reasonable doubt and hence absence of probable cause is it not per se the reason of acquittal. So this is a wrong option. B says the plaintiff claim for malicious prosecution should be dismissed since he couldn't establish that he was harassed and no malice was proven. This is the right option because fact clearly says that he was unable to prove that the police officers harassed him and hence there was no malice on the part of police officer and he was not harassed by the police officer. So this is the right option. C says the plaintiff should be compensated for harassment even though he couldn't prove malice as his acquittal shows the absence of sensible and probable reason for prosecution. Again, just because he was acquitted doesn't show the absence of probable or sensible reason for prosecution. So this is the wrong option. D says the plaintiff's malicious prosecution claim should be upheld as his acquittal alone establishes malicious intent on the part. Again, a wrong option. Acquittal is not a sole criteria for judging malicious intent. There should be a malicious malice proven on the part of the other party, and there should be damages being caused to the plaintiff to file an malicious prosecution suit. Let's see the ninth question. It says, in a case, the plaintiff Uma Shankar Pathak, an advocate and leader of Jansangh, was arrested and later acquitted for being falsely implicated in a case by Sub Inspector Giriraj Prasad. The High Court found that Giriraj Prasad's report was false and plaintiff was not present at the scene during the incident. Who should be held liable for malicious prosecution in this case? The facts clearly established that there was false implication. मतलब जो शंकर उमा शंकर पाठक के ऊपर जो केस था वो falsely implicated था. और वो falsely कैसे implicated था? क्योंकि जो रिपोर्ट सब इंस्पेक्टर ने सबमिट की थी वो false निकली थी बाद में ऑन इन्वेस्टिगेशन. एंड तो हमें इसमें बताना है कि मैलिशियस प्रोसिक्यूशन के लिए कौन लायबल होगा. लेट्स सी ऑप्शंस. ए से सब इंस्पेक्टर गिरिराज प्रसाद शुड बी हेल्ड लायबल फॉर मैलिशियस प्रोसिक्यूशन बिकॉज ही फाइल्ड अ फॉल्स रिपोर्ट. परफेक्ट. फॉल्स रिपोर्ट आपने फाइल की जिसकी वजह से जो प्लेंटिफ है एडवोकेट उनके अगेंस्ट एक मैलिशियस इंटेंट आपका एस्टैब्लिश हुआ. मैलिशियस इंटेंट की वजह से उन्हें डैमेजेस हुए एंड हेंस यू आर लायबल फॉर मैलिशियस प्रोसिक्यूशन. सो दिस इज द राइट ऑप्शन. बी says SHO of the territory should be held liable for malicious prosecution for entertaining false report. Although SHO can be held liable, but through the facts present in the question we cannot see whether SHO was involved in such malicious prosecution or not, and hence he cannot be held liable until unless there is a proof that he also had intent of malice. So this is a wrong option. C says both Inspector Giriraj Prasad and SHO of the territory should be held liable for malicious prosecution. Again, SHO can only be held liable for when there is malice on his part is proven. So this is a wrong option. D says the other two people associated with the case should be held liable for malicious prosecution for their involvement. There is no mention of such other two people in the facts, so we can rule this option out. Last question. In the case of malicious prosecution, what elements plaintiff must prove to be successful in their lawsuit? अब हमें अगर एक malicious prosecution का सूट फाइल कर रहे हैं तो हमें क्या क्या प्रूव करने की जरूरत है in order to be successful? Let's see. A. The defendant initiated criminal bankruptcy procedure with reasonable justification. Just proving that there was a criminal or bankruptcy procedures with reasonable justification is not enough for filing a malicious prosecution, hence this is a wrong option. B says the plaintiff did not suffer any damages as a result of prosecution. Suffering of damages is important for proving malicious prosecution, so this is saying opposite of what is true. So this is again a wrong option. C says the prosecution was initiated by malice. मैलिस था उस प्रोसिक्यूशन में विदाउट जस्ट एंड रीजनेबल रीजंस वो इनिशिएट किया गया था एंड इट वाज रिजॉल्व्ड इन द फेवर ऑफ प्लेंटिफ. दिस इज स्टेटिंग ऑल द थ्री रिक्वायरमेंट्स व्हिच आर नेसेसरी फॉर मैलिशियस प्रोसिक्यूशन. सो दिस इज द राइट ऑप्शन. डी सेज प्लेंटिफ ओनली नीड्स टू प्रूव दैट डिफेंडेंट अब्यूज द प्रोसेस ऑफ कोर्ट ऑफ लॉ विदाउट एनी मैलिस. अब्यूज ऑफ प्रोसेस ऑफ कोर्ट ऑफ लॉ तो नेसेसरी है बट इसके साथ मैलिस भी प्रूव करना इंपॉर्टेंट है which is not being highlighted in the present option. So again this is a wrong option. With this we are done with the passage. I hope it was understandable. Keep studying and all the best.